Work made for hire, WFHI Introduction 1. Importance. According to the general rule of authorship, creations can only be made by a natural person, and only the actual creator of the work can attain the primitive authorship of the work. But in the Korean copyright law lies a vital exception. The law recognizes the relation between a natural person and the legal person and allows legal bodies to attain legal authorship. Article 2, Section 31 of the Korean copyright law clarifies the meaning of the statutorily defined term work made for hire, WFH, as works made by an employee of a legal person, an organization, or another employer, herein referred to as legal persons, etc., during the course of his or her duties and on the initiative of the legal person, etc. Article 9 regulates the authorship grants by stating that the author of work made for hire, which has been made public under the name of the legal person, shall be that of the legal person unless otherwise stipulated in a contract or work regulation. The importance of work made for hire can be understood if the technical nature of the works will be accounted for. Currently, works are created within legal persons through cooperative projects. This consequently results into difficulties in proportionally segregating the works, which is caused by either the technicality of the work itself or the complex aggregation of contributions provided by multiple individuals. In addition to such reasons, the importance of granting primitive authorships to legal persons is also due to the simplification of legal relationship. This simplification allows convenience in the usage of copyrights. 2. Requirements. 1. Hirer. The hirer stated in Article 9 of the Korean copyright law is not limited to those legal persons with personality, but also includes central government, regional government, companies, schools, and other types of organizations. Foundations and corporations without legal personality can also be hirers if a president or manager is appointed. Individuals can also be accepted as the hirer as there are no rules restricting the matter. 2. Works made in the initiative of the legal person, hire relationship. The hire relationship between two entities is judged by the existence of actual supervision. The legal relationship between employer and employee does not suffice the requirement if no actual supervision was conducted during the course of work. Hire relationship between the two entities cannot be accepted. The legal relation between an employer on long-term leave and employee will be maintained, but the hire relationship provided by Article 9 between the two entities will be discontinued as no actual supervision was conducted during the course of duty. Contract-based relationships are not included in the hire relationship as the contractor stands as an independent party and acts according to its discretion. As copyrights are based on the artistic style, technique, creativity of the work, the legal author of works that result from plans provided by clients will be granted to the contractor if the work's decisive factor would based on the contractor's mental effort. Conversely, if a contractor acts as a tool for creating a work, the hire relationship between the entities can be accepted, and thus the client becomes the legal author of the work. In cases where both entities provided contributions, a joint authorship will be granted to both the client and the contractor. 3. Works made under the course of duty. Works must be made under the course of duty. To elaborate this in more specific terms, the creation of the work must be the duty. If a work is created indirectly during the course of duty, the work is entitled to the creator and not the legal person whom the creator is a part of. The following are instances where authorship belonged to the creator: a work created by a public official through the knowledge and experience procured through the course of duty, and a work created by an employee under his or her own leisure time to effectively complete his course of duty. 4. Work made public under the legal person. Article 9 cannot take effect if the work was made public under the name of creator, even though it has been created during the course of duty. Article 9, however, grants authorships to legal person on non-publicly announced works if it is scheduled to be made public in the near future. The provisional clause of Article 9 states that computer program works do not require to be made public under the name of the legal person. This is due to considerations made regarding technicality of the computer programs. Computer programs undergo multiple test phase versions that are not scheduled to be made public. If public announcement would be required for computer programs, the author of the test versions would be the employee and would result to a conflict between the test version and final version. The provisional clause also considers that some computer programs utilize other computer programs without permission and that some computer programs must be protected as trade secrets. 5. Non-existence of special contracts or work regulations. Even if the other 4 requirements are met, if a special contract or work regulation exists between the two entities, the special contract or work regulation is prioritized. Thus, the establishment of work made for hire (WFH) requires the non-existence of such special contracts or work regulations. But in reality, cases that include such contracts between two entities are also nearly non-existent.